I walked a mile with pleasure. She chattered all the way, but left me none the wiser for all she had to say. I walked a mile with sorrow, and not a word said she, but oh, the things I learned from her when sorrow walked with me. My name is Connie Marsh, and this is our story. In February 2014, my husband Floyd Marsh Jr. was arrested during a traffic stop while visiting Chicago. He had retired in 2007 from 29 years in law enforcement, and there was no probable cause for his arrest. The officer, Ron Hain, found no marijuana in my husband's truck, only money and legally registered guns, all of which he seized. The Washington Post connected Hain to Black Asphalt, a controversial police training group known for the unscrupulous seizure of citizens and their cash. Marsh remained jailed until May 2016 when the canine handler admitted lying about the drug hit on Marsh's truck. Prosecutors dropped all charges, the judge scolded the officers. Marsh and several others won settlements against Hain for violations of 14th Amendment rights. Unfortunately, Marsh's 2014 arrest led to embarrassing headlines, from which his former boss, Sheriff Craig Roberts of Clackamas County, Oregon, took immediate steps to distance himself. Shortly thereafter, Clackamas deputies arrested a longtime associate of Marsh, one Gerald Weiss, with large amounts of meth, heroin, and cocaine. Weiss also confessed to participating in a 2011 home invasion robbery. Of course, Weiss blamed everything on Marsh, so as soon as Marsh's Chicago troubles were over, he was brought home to Oregon, where he faced 8 robbery-related charges. In 2017, he was convicted on half of them by a split jury. In 2018, Marsh arrived at Two Rivers Prison. The yard greeted him with a sea of red snow, where the inmates had recently rioted. In 2020, COVID hit the prison, killing dozens. Marsh survived, barely. After his appeal was denied, Marsh filed a pro se post-conviction relief. He was appointed a Portland attorney who negotiated a remand. Marsh returned to Clackamas County Jail, and I bailed him out in April 2022, free for the first time in over 8 years, pending a new trial. That's pretty fast compared to most exonerees. He is innocent and never should have been arrested, charged, or convicted. His case spotlights a nationwide concern. We truly don't know the extent of the problem and how many people are serving time for something they didn't do, because the government doesn't track these statistics, but many estimate it's 6 to 10% of prisoners. Solutions will first address these ones sitting there waiting for us to act. Prosecutors need oversight, and trials must be based on truth. In the next section, we will explore a history of wrongful convictions and introduce the role of the prosecutor. Next, we will dissect the major causes of wrongful convictions and talk about their harms. Finally, we will examine remedies and their challenges. The earliest known case of exoneration in the U.S. was for an 1812 murder. 2 brothers confessed in order to escape the death penalty, only to have the alleged deceased return to town years later in Huck Finn fashion, quite alive. In 1992, the Innocence Project founded its first chapter, and it has since grown into a huge coalition. It's exonerated over 3,000 people so far, mostly through DNA testing. Since 1989, DNA testing has been a forensics game changer, especially in cases of rape and murder. The National Registry of Exonerations does not claim to be an exhaustive list, but it is a great data resource. District attorneys are elected to public office. They and their staff prosecute crimes. They're exempt from all civil liability, even when they knowingly present false evidence to convict the innocent. Here are the top causes for wrongful convictions. They're shown in order of historical prevalence, although it should be noted that misconduct rose to number 1 in 2021. Mistaken identity accounts for about 75% of DNA exonerations. A common cause is that research proves humans are not able to well identify those of another race beyond the age of 9 months of age. And secondly, police lineups are flawed because they force the crime survivor to choose the person who most reminds her of her recollection of the perpetrator. Also, victims tend to assume the person must be in the grouping, otherwise, why would the police have brought him in? In the Marsh case, police never showed the elderly robbery victim any lineups, photo or otherwise. Rather, they quickly ushered her out of the courthouse lobby so she couldn't see Weiss brought into the grand jury. Had she identified him, it would have ruined the prosecutor's version of events. Even so, she had known Marsh for years by then, and she hasn't ID'd him as her attacker to this day. Forensics may exonerate some, but they're only as good as a scientist. Massachusetts has tossed out almost 30,000 convictions due to the unethical actions of 2 lab chemists. False confessions, that's confusing. Why would someone say they're guilty when they're not? Well, police are not only allowed to lie to suspects, they are well trained to do so. So if an innocent person is convinced that prosecutors can and will convict them, they may seek to mitigate damage by accepting a plea deal for lesser time than they'd get if they had lost at trial. Suspects have less than a 1% chance of being acquitted at trial, so is it any wonder why about 95% of these cases end in a plea deal before that? Investigators never interviewed Marsh. They refused his requests for interviews. Prosecutors never offered him any deal pre-trial either, opting instead for the headlines that his case brought. But once his conviction was quietly vacated well into his wrongful sentence, the prosecutor, Russell Amos, indicated that he was open to resolve the matter so that Marsh could go free. Marsh rejected this thinly disguised offer of time served, and we posted bail instead. Informants. To strengthen their cases, prosecutors might grant incentives to criminals in exchange for their testimony against another defendant. Conflicts of interest in this practice are the most obvious problem because informants must choose between their own freedom being dangled for ransom and someone else's. They are almost never prosecuted if they lie, unless they recant. A second problem with informants is that juries tend to believe them. Prosecutors are required to reveal terms of deals they make with informants. In Marsh's case, though, the prosecutor has never provided any details concerning the consequences by which he absolved Weiss of robbery, assault, and money laundering. We know only of the deal in which he arranged leniency for Weiss's multiple drug trafficking charges. It's also worth noting that even though Weiss changed his story in all 3 proffered interviews plus grand jury and then again at trial, Amos held up Weiss's interviews to the jury as absolute proof of his transparency and honesty. The U.S. Constitution grants legal counsel to defendants of little means, and so that's about 80%. However, Oregon's public defense system runs at a 69% deficiency, and so it has been labeled unconstitutional. When waiting in jail for trial, Marsh created an 81-page rebuttal to discovery, which his public defender refused to read it, citing time constraints. Later, when Weiss changed his testimony on about 100 material points from proffer to trial, Marsh's attorney didn't even notice. You can read about it, however, at the innocencefoundation.org cases page, Amos Weiss Project. Marsh appealed. His appellate attorney failed to preserve his rights. His appeal was denied just 4 days before the Supreme Court ruled on Ramus, which is a landmark case that outlaws non-unanimous jury verdicts like his. Ironically, though, Marsh and his proverbial jailhouse lawyer had meanwhile filed a PCR that did preserve his right, and it was granted in 2022 as mentioned. As you can see, misconduct works well in tandem with other factors. If prosecutors believe someone is guilty, they might be tempted to cheat a little to ensure a conviction. But if they know a person is innocent, they may prosecute solely for personal gain. When caught, they are publicly scolded less than 1% of the time. 80% of the time, judges rule misconduct is harmless. It never automatically overturns a conviction. But if it's so inconsequential, why do they do it? Clearly, it provides some unfair advantages and at least a suspicion of harm. Police conduct can be seen and videoed. Their decisions are split second. They have only qualified immunity. None of this holds true for prosecutors, who are, for all practical purposes, an elite class above the law with absolute power. Marsh's prosecutor withheld exculpatory evidence, contradicted the crime survivor's testimony, introduced facts into his arguments that were nowhere in evidence, praised his informant while bashing Marsh, and allowed his co-worker from the DA's office to sit on Marsh's jury. One should not discount political pressure on prosecutors. In another of Amos's 2014 cases, a Michael Oren shot and killed a man in a marijuana theft gone wrong. Amos bribed Oren with leniency if he'd just withhold any testimony beneficial to one Francis Paul Weaver. Weaver was not the shooter, but like Marsh, he was the most newsworthy. His stepdad and grandpa were both convicted murderers, so when he was convicted as a third-generation murderer, Amos predictably made the evening news. But wait, In 2020, Oregon's Supreme Court threw out that verdict, claiming Amos's deal was tantamount to witness tampering. You can read about that on the cases page of innocencefoundation.org as well. Keep in mind that in the Weaver case, Amos had required only silence, but in Marsh's, he'd required perjury. The prison experience does not differentiate between the guilty and the innocent. One study says that every year in prison takes 2 off of life expectancy. Exonerees experience PTSD like a prisoner of war. They rarely get compensation. Apologies are even rarer. But even if we tried, how could we put a price on liberty, account for compounded lost economic opportunities, or calculate the loss of a parent to a child? Wrongful convictions also fail to meet the objectives of crime survivors. Any closure they gain through a wrongful conviction is artificially gained at the expense of an equally undeserving person. Wrongful convictions harm communities too. The Constitution claims to strip liberty only from the guilty, but when it breaks that promise, then fewer obey the law. Blackstone wrote, "It is better that 10 guilty escape than 1 innocent suffer." But is it just a matter of a tidy trade-off? His modern challengers would have us believe that we can either free more or free less. I say it's not an either-or discussion. It's a two-sided coin. Every person wrongfully incarcerated represents, oh no, creates another who is wrongfully freed, who then becomes empowered, as Weiss was, to go out and get arrested with more drugs less than 60 days after Marsh's trial ended. Legal custom truly dictates it is more reprehensible to punish the innocent than to fail to punish the wicked. Jesus depicted righteous ones as wheat and wicked ones as weeds, who must be allowed to coexist until harvest in the field, so as not to destroy one with the other. This highlights a paramount principle. If ever there is a conflict between justice and mercy, then mercy is to prevail. Among worthy proposed reforms are a repeal of portions of the 1946 Federal Tort Claims Act that grants impunity to prosecutors, replaced with laws that specify discipline schedules for their misconduct, mandatory reporting to state bars, automatic conviction reversal, clearer ethics training, and transparency of violation records to juries and others. These must first apply to currently wrongfully convicted ones, otherwise there will be no motivation for prosecutors to change. Reforms must also be outsourced. Conviction integrity units have recently become popular, but they are not the answer. First, they're voluntary. Second, they're an added bureaucratic layer and just an internal division of the prosecutor's office. Do we really think they're honestly going to investigate, openly report on, and then punish themselves? Third, they kick in only after all these other responses, which are unconcerned with the truth, are exhausted. People can't appeal on innocence, only on technicalities, because people are not promised a fair procedure. They are only promised a fair procedure, not a just verdict. But of what good is the best map in the world if it leads to the wrong place? In the Marsh case, the contributing DAs should apologize to Marsh and the crime victims and pay them reparations. They should return what they took from all of them and have Weiss do the same. The Oregon State Bar should consider lack of remorse and extent and duration of harms when they vote to disbar Russell Amos. Weiss should remain in prison. The Imbler Court appears to have believed that democracy as we know it might collapse if we curtail misconduct, but prosecutorial discretion should be monitored and tempered. It should never be exempted from consequences. Some people feel this will all just cost too much time and money. Well, America spends $182 billion per year on incarceration. Doesn't it cost the same to lock up the guilty as the innocent? And time? Let's ask the 3,000 plus exonerees on the National Registry who've collectively lost over 27,000 years of their lives what they think of our time constraints. Others question whether it's really possible to judge a prosecutor's motives. But the law already does this. It requires juries to determine mens rea, or mental state, in wrongful death cases to assign culpability, such as between manslaughter and murder. Why not apply these same rules of evidence to ascertain prosecutorial misconduct? Others say humans are simply infallible, so we can expect some error. Remember, malice is not an accident. One prosecutor actually argued before the Supreme Court in 2009 that citizens do not have the right not to be framed. But I say, if it's predictable, it's preventable. By establishing reforms and outsourcing their oversight, we can improve the situation. The Marsh case can serve as both a warning and a prototype for remedies. Doing the right thing will yield good dividends. So that concludes my paper, but would you like to know the rest of the story, as Paul Harvey used to say? After serving as Clackamas County Sheriff for 16 years, Craig Roberts retired in disgrace in 2020 after it was discovered that indeed one of his deputies had, in fact, knelt on the neck of a black 12-year-old child at the mall. And what of Officer Hain in Illinois? Well, the good people of Chicago went on to elect him as their next sheriff. Thank you for your time. It's been a privilege. Feel free to check out our website and watch for our book on Amazon next year. Blessings.